everyone, welcome to this lecture. Dear aspirants, in today's session, we are going to discuss about the recent judgment of Supreme Court on Narco Test. In this video lecture, first we will discuss the context, what is the context. Moreover, we will see all the constitutional provisions regarding Narco Test. Apart from that, we will also discuss the ethical concerns or ethical aspects related to Narco Test. Let's begin. First, what is the context? See, the context is that the Supreme Court in its recent judgment has set aside the order of Patna High Court in which the Patna High Court had permitted narco test in Amlesh Kumar versus State of Bihar, and it was permitted involuntarily, means it was a kind of forced narco test, right? And that's why the Supreme Court set aside the order of Patna High Court and called it unconstitutional and invalid. Why unconstitutional and invalid? Because it was means consent was not taken. So simply Supreme Court held that any forced involuntary narco test shall be unconstitutional and invalid, setting aside Patna High Court order that permitted such a test in Amlesh Kumar versus the State of Bihar 2025. Right? That is the main issue. In this case, means in this judgment, the Supreme Court held that the order of Patna High Court was in contravention of the guidelines given in the Selvi versus State of Karnataka 2010. So this case is very important. Selvi versus State of Karnataka 2010. In this case, a bench of 3 judges of Supreme Court had issued certain guidelines regarding narco test. That these guidelines should be followed while performing narco test. Now, what is narco test? So simply, you must be knowing about narco test, that a kind of investigation process, right, in which certain substances are injected in the body of accused person. For example, sodium pentothal or sodium amestel, right? Like narcotic substances are injected in the body of accused person, and he or she is expected that he or she will lose his logical ability or reasoning ability, and that accused person will reveal certain concealed facts. Simple. That is the meaning of narcotic test. As I said, a process of investigation during which it is expected that the accused undergoing such a test would express the concealed facts. And which kind of substances are used? For example, sodium pentothal or sodium amestel, right? And it is a non-violent method similar to those called polygraphy or polygraphs or mind mapping. So, but it is called non-violent method because the accused is not beaten or not tortured or not forced by the investigating agencies like police. Simply, certain substances are injected in his or her body, and that person loses his logical ability, reasoning ability, and supposed to reveal concealed facts. But such statements or any statement given during narco test, right, is not acceptable by the court as a permanent evidence, right? Though it can be substantiated, but it is not reliable. It is just considered as a statement given in front of police, right? Now, let's see the constitutional provisions. So first, why are such tests constitutionally problematic? See, such test means narco test is violation of Article 20 Clause 3. So what is Article 20 Clause 3? It is protection against self-incrimination, right? Protection against self-incrimination. It simply means that no person accused of an offense shall be compelled to be witness against himself. For example, X is a person, right? And that person is accused in a case, right? Though that person is accused, in spite of that, X cannot be forced by the investigating agencies, for example, police, right, to give witness against himself, right? He cannot be forced. No one can force that accused person, right? That is all about Article 20 Clause 3, right? Though you have been arrested in a case, you are an accused, but no one can force you. Means neither the investigating agencies, for example, police, can force you that give statement against yourself or accept these crimes, right? You are not supposed to do that. Simply. So The Supreme Court, relying on the Selvi versus State of Karnataka guidelines, Selvi versus State of the Karnataka guidelines, has held that conducting such test, means narco test or narco analysis test, without free or informed consent is unconstitutional. It simply means that before performing any kind of narco test, right, or even it is applicable in polygraphic test or mind mapping, right, consent is very important, right. And in while discussing this case, Selvi versus State of Karnataka 2010 is very important, right. In this case, as I said, bench of 3 judges issued certain guidelines that these guidelines should be followed during performing narco test. Next, any information obtained through these facts cannot be used as evidence if consent is absent, right. So if consent is not taken first, then it, right, then it shall be considered as unconstitutional, invalid. And again, the consent is absent, then it's that evidence, right, or that statement cannot be used as evidence. Next, let's see article 20. So article 20 has 3 clauses, right. Clause 1, clause 2, clause 3, right. So clause 1, it prohibits ex post facto criminal laws, right. Ex post facto criminal laws, it simply means that no person can be punished from back date, right. Back date means, just an example, X, right, has committed a crime on 1st January 2025, right. And in that case, or for that crime, right, punishment was for just 3 years, right. Now what happened, that on the same day or on the another day, next day, just an example, on 2nd January 2025, the government brought a law, right, brought a law, and for the same punishment, for the same crime, now the punishment has been increased to 7 years for the same crime, right. But X will get only 3 years punishment, means 3 years imprisonment, right, not 7 years imprisonment. That is the simple meaning of ex post facto law. Ex post facto means you cannot go back in the past. You can reform the criminal law and you will punish the accused, right. Only you can punish the accused as per the present law, but it is not applicable in case of civil cases, right. Civil cases or civil offenses, civil cases, for example, tax related laws, these are related to civil cases or civil laws, right. So ex post facto is not applicable in civil cases, only in criminal cases. I hope I am clear, right. Next, clause 2, so it protects against double jeopardy. Double jeopardy means what? No person can be punished for the same offense more than once. For example, X has committed a crime and he was rewarded or she was rewarded 5 years imprisonment, right. Now no case can be filed in any court within the territory of India for the same offense, because the person has been already awarded the punishment of 5 years, right. So no double punishment for the same offense, but there is one exception, right. What is it? It is military court, right, or simply just listen, military court means if you are a personnel of army, armed forces, navy, then double cases can be, right, started. For example, in the judiciary as well as in the military court, right. This is an exception, but for civilians, right, it is only once, means any person in India can be punished only for once for the one offense, right, except military personnel, right. And this is done or ruled under military rules, right. For example, Navy Act, Air Force Act, or Army Act. Next, clause 3, we have already discussed. What is it? Safeguards protection against self-incrimination. It simply means what? That you cannot or no person accused of an offense shall be compelled to be witness against himself or herself. For example, if, as I said, a person Y, right, has committed a crime, right, police or investigating agencies cannot force Y to accept that crime, right, to sign a statement that you have committed the crime, right. If it is done, then it is violation of Article 20 Clause 3. Simple. So narco test is also considered, if the consent is not taken, then it is considered as what? Constitutionally problematic, means violation of Article 20 Clause 3. Simple. So together these three clauses form the constitutional bedrock of the India's criminal justice system. Right? Next. So guidelines which was issued in the Selvi versus State of Karnataka, you must know, and you can use these lines or these points in your means answers. So simply, as I said, that a bench of 3 judges of Supreme Court issued certain guidelines. And what was the first guideline? No test shall be conducted without the voluntary consent. Right? As I said, the first important thing is consent. Consent is required. Consent is very important, right? Of the accused, who must be given the option to refuse. Yes, right. Means the accused has both options. The accused can accept or refuse to give his or her consent. Right. And if it is involuntary or forced, it shall be considered as unconstitutional or invalid. Second, consent must be recorded before a judicial magistrate. So first important thing, voluntary consent, right? And the accused has option, he or she can refuse. Second, the consent must be recorded before a judicial magistrate. Third important point, accused must be represented by a lawyer at the time of giving consent. So judicial magistrate, right? Again, that accused person must be represented by his or her lawyer while giving consent. Fourth, accused must be clearly informed that any statement made will not be treated as confessional statement. Right? Already I have explained that any kind of a statement given during narco test, right, shall not be considered as confessional statement. Only it shall be considered as what? A statement to the police, just like any general statement given to the police. And you must be knowing that any statement given in front of police is not valid until you give the same statement in the court of law. Right? In simple terms, any statement given in the or in front of police is not valid in the court of law until the same statement is repeated in the court of law. Right? For example, X, right, has accepted that he has murdered someone. Right? For example, Y, right, in front of police. Right? In front of police, X has accepted that he has murdered Y. But in the court, right, he denies that no, I have not given such kind of a statement. Right. So such type of a statement given in front of police is not valid until the same statement is repeated or given in the court of law or recorded in the court of law. That is the simple meaning. So next, magistrate must examine all relevant factors, including the nature of interrogation and duration of detention. Obviously. And last, a detailed factual and medical record of the procedure and manner in which information was obtained must be maintained. So all records should be mentioned. And what are the key aspects? First, consent is important. Second, must be recorded in front of judicial magistrate. Third, represented by a lawyer. Fourth, that it is not to be treated as confessional statement, just a statement to the police. Next, magistrate must examine all the relevant factors. For example, medical related issues, right, or all the relevant factors. Last, detailed and factual medical record must be maintained. Simple. So these guidelines were issued in the Selvi versus State of Karnataka. Next important thing, as it is related to right to life, right, and right to life comes under Article 21, right? So simply, why are such tests constitutionally problematic? Balance between victims' rights and accused rights. See, in any case, there are two parties, two aspects, criminal or accused or the victim. So their rights means both have rights, the accused as well as victims, and their rights should be balanced. Their rights should be fair, right? So a democratic criminal justice system must maintain a fair balance between rights of victim and those of accused. Both have rights. Even you are a person is a terrorist, he or she has certain rights. You are a victim, you have certain rights, and it should be balanced, right? That is the expression, or you can say what a democratic criminal justice system should include. Next, compelling an accused to undergo such test undermines this balance and erodes democratic values. Obviously, when you force someone to go under such test, for example, narco test, and it is also, I would like to tell you that sometimes it is life taking or very dangerous, right? It may cause or the send the person to the coma, or sometimes it causes death, right? If it is or narco test is administered in wrong manner, it sometimes causes death to the accused, or sometimes the accused go into coma, right? Violation of Article 21, right to life, personal liberty and privacy. Obviously, right? Whenever whenever your life is in danger, right, it hampers your right to life, your liberty. And apart from that, whenever some concealed facts are revealed, right, it may happen that during your unconsciousness, right, what happens that when narco test is performed, as I said, certain substances, sodium pentothal or sodium amystal, right, is injected in the body, and the logical section, right, logical ability, reasoning ability of that person is lost for certain duration, for example 3 to generally 3 to 4 hours, right? During that time, the person may reveal certain unwanted facts, certain secrets that is not relevant to case, but may be dangerous for that person. So it also violates the privacy of that person. And all these are right to life, liberty and privacy are part of Article 21. Simple. Next, as Article 21 encompasses right to privacy, which includes bodily and mental autonomy. Obviously, now give one answer in which case the Supreme Court propounded right to privacy as a part of right to life. You can comment the name of case in the comment box. I am repeating the question. In which case the Supreme Court held that right to privacy is part of right to life. You can name the case in the comment box. Conducting such test without express consent amounts to an infringement of personal liberty and human dignity. Obviously, as I said, it endangers your life, right? You can go into coma, right? It can cause your death, means accused death, right? So what it infringes personal liberty, human dignity. When your privacy is violated, your dignity is compromised, right? Apart from that, breach of golden triangle. So what is golden triangle? See, what happened that in Menka Gandhi case, right? Menka Gandhi case, 1978, the Supreme Court held that three articles, articles, three articles, 14, 19, 21, are golden triangles. Article 14, Article 19, Article 21 are called golden triangle. Why golden triangle? Because Article 14, right to equality, Article 19, right to freedom, Article 21, right to life and personal liberty. So for any individual, these three rights are intrinsic, right? Very important. And that's why in Menka Gandhi case, Supreme Court called these three articles, means these three rights, Article 14, 19, 21 as golden triangle. And right, Article 14, 19, 21 already I have explained. A violation of privacy under Article 21 would also implicate equality, Article 14, and freedoms under Article 19, thereby disrupting the constitutional balance. So, if any right is violated, right, any article is violated, right, it disrupts the constitutional balance. Simple. So you can see that we have seen that it is unconstitutional as per Article 20 clause 3, right? Apart from that, it also affects Article 21, Article 14, Article 19, right? And Indian criminal justice system mainly relies on Article 20, right? All these safeguards under clause 1, clause 2, clause 3 are related to criminal justice system. Next, what did court say about the evidentiary values of narco analysis test? So, two cases are important here. Manoj Kumar Saini versus State of MP 2023 and Vino Bhai State of Kerala 2025. So in these two cases, the courts means right held that narco test results do not establish guilt. It simply means you have to remember that narco test results do not establish guilt. Means any, as I said earlier, that any kind of statement given during narco test shall not be considered as confessional statement, just an statement given before or in front of police, right? So it cannot prove or it does not prove the guilt, right? And on the basis of this statement or such statements, the accused cannot be proven guilty and he cannot be punished. Simple. So next, information obtained through such test may aid investigation. Obviously, such type of statements given during narco test or narco analysis test may help the investigation, but cannot be treated as substantive evidence. So such statements can be right considered as additive statement, not as substantive evidence, and the accused cannot be proven as guilty. Right? Next, and any such information must be independently corroborated by other admissible evidences. So simply, such statements should be supportive evidence or considered as supportive evidence, not as the main or substantive evidence. Next, requirement of the informed consent. Obviously, we have discussed that consent is very important, right? It must be performed in front of judicial magistrate, right? Accompanied by medical, right? It should be administered by a medical practitioner. Medical practitioner means a doctor, especially an specialist of anesthesia, right? Legal and procedural safeguards. Next, Article 21, we have already discussed, right? So, just have a quick look. Article 21, it incorporates what? Procedure established by law. And what does it mean? It simply means that the procedure to be fair, just and reasonable, right? Any procedure, right? Any procedure means any legal procedure should be fair, just and reasonable. That's all, right? Again, limited permissibility under criminal procedure. The court has clarified that an accused may voluntarily opt for a narco analysis. Right? You are an accused. Right? You are giving your evidence that no, I am innocent. I am not involved in that crime. Right? You can or yourself you can opt for narco analysis test. Right? That, but it is not your right. Right? And where it is written? It is written under section 253 of BNSS. Right? Section 253 of Bharatiya Nyaya Suraksha Samhita. Right? So the accused can opt for what? Narco analysis test. But remember one thing, as I said, that it is not his or her right. So, however, there is no indefeasible or enforceable right to demand such a test. Even the court can deny that no, though you have opted for, it is your voluntary choice, right? That narco analysis test should be performed, right? But the court can deny, and it is not your right, means not the right of the accused. So one way, if the investigating agencies, right, for example police, want to administer narco analysis test, then the police must take consent of the accused person. On the other side, as per section 253 of BNSS, right, if the accused opt for narco analysis test, even the court can deny, and it is not his or her right. Simple. And most important thing you must remember, that the statement given during narco analysis test, right, is or cannot be considered as confessional statement, just as an statement given to police, right. It can be additive but cannot be considered as substantive. Now, ethical aspect. So it also affects the ethical aspects, right. For example, Emmanuel Kant says that an act is ethical only when performed with free consent, right. If your consent is taken, then that or such acts should be considered as ethical. If your consent is not taken, if you have not given your consent, it is unethical. Simple, right. And it is one of the core principle of natural justice, right. And as I said earlier, that the accused must be informed by the investigating agency, right, that a narco analysis test is being administered on you, and it is up to the accused person that he can or she can give his consent or refuse, right. So certain key aspects you must remember. First, the consent, the accused person must be given the inform, or he or she must be informed about the narco analysis test first. Second, the accused can give his consent or he or she can refuse. Third, it should be or the consent must be recorded in front of the judicial magistrate. Next, the consent or the accused must be represented by his or her lawyer. Apart from that, certain records should be mentioned of the narco analysis test, and any kind of a statement given during narco analysis test cannot be considered as substantive statement, only just a supportive or additive statement, right. So accordingly, forced or involuntary narco test violates ethical principles, human dignity, fundamental human and natural values. So this was all about Supreme Court's judgment on narco analysis test. We have seen the constitutional provisions as well as ethical aspects. Thank you.